Good morning. We are here live. We are going to get started with the latest immigration news. What's going on with immigration in general? And we're going to take questions. So let's get into it. Say hi in the comment. Yep, say hi in the comment if you're here. And let me know where you are watching me from. Hi in the comments. Say hi in the comments. Hi, Bulewu Lukengo. How are you? Hi, Yolanda Castillo. How are you? From Iowa. Yeah. So, Yolanda, where are you watching me from? Castillo. Hi. Oh, from New York. Yeah. I'll be in New York next month, actually. Uh, yeah, I love New York. Anyway, so what's going on with immigration? Well, we have some news. One is good, and some are just news. Um, at least let's get started, right? So let me share my screen. Share my screen here. Entire screen. Okay. Share. Okay. Let's start with this program, CAM. Okay, the Central American Minors Program. We know this program was canceled under Trump in 2017, right? Basically, this program started under Obama in 2014, and then when Trump came into power around 2017, he canceled the Central American Minors Program. But guess what? It is back. So, what is the program? Who can benefit from it? Let's get into it. So, about the program, so the program provides certain qualified children who are nationals of El Salvador, Guatemala, and Honduras, okay, as well as certain family members of those children, an opportunity to seek refugee status and possible resettlement in the United States. So it's pretty much helping some people from Central America, okay? It's pretty clear. El Salvador, Guatemala, and Honduras, okay? And who can apply? Only certain parent or legal guardian who are lawfully present in the United States may request access to the program for qualifying children, okay? A qualified child must be unmarried under the age of 21 and a national of El Salvador, Guatemala, or Honduras, okay? In some cases, an in-country parent of the qualifying child may also qualify for access, okay? Children of qualifying child or other eligible family member may also qualify if those children are under the age of 21 and unmarried. So that was the goal for the program. But right now, they've changed some eligibility criteria, okay? So qualifying parent or legal, let's see the qualifying criteria, okay? Qualifying parent or legal guardian. So who is the qualifying parent who is actually qualified to apply? You have to be US based. Qualifying parent, basically you're living here in the US, or you must be a legal guardian still living in the US, must be at least 18 years old and in the United States in one of the following category. You can be a lawful permanent resident, temporary protected, you can have a temporary protected status, TPS, you can have parole at least for a minimum of 1 year, defer action for a minimum of 1 year, defer enforced departure, withholding of removal, you might have a pending asylum application filed on or before April 11, 2023, with a pending U visa petition filed on or before April 11, 2023, or with a pending T visa application filed on or before April 11, 2023. Those are the good things, right? If you look at those qualifications here, especially the before last one, usually you have to wait until you get an approval to petition for your children, right? And this withholding of removal, usually you don't even have the right to petition for your children if they're outside. But what's going on is you can file an application for them, but it's very specific, right? So, and what is the qualifying child? Basically, their criteria of qualification. The qualifying child at the time they're filing this program must be the child genetic step or legally adopted of the qualifying parent and married under the age of 21, physically located in El Salvador, Guatemala, or Honduras, and a national of El Salvador, Guatemala, or Honduras. Only those three countries, and you have to be physically located in those countries, okay? This one says if the qualifying parent submitted an AOR before November 9, 2017, and their qualifying child later reached the age of 21, the child is still eligible for the purpose of current application. Well, if they submitted the application to 2017, so basically when Trump came to power, right, the application was, the entire process was canceled. But now they're saying that if you submitted that on that date or before that date, around that date, and the child now has reached the age of 21, the child is still eligible, okay, to come. So in some cases, the following eligibility member may be access to the program when included with a qualifying child: unmarried children of the qualifying child who are located in the country. Let's say your child is unmarried and has a child. Pretty much it's going to be like your grandchild, right? Under the age of 21, be included as the derivative, okay? And in-country parent of the qualifying child may be included if they are part of the same household and economic unit as the qualifying child, are legally married to the qualifying parent in the United States at the time the qualifying child filed the application, and continue to be legally married to the qualifying parent at the time admission of parole. You see how you can, when it becomes a little bit broader, right? So, yeah. Then they talk about eligibility for family member. Here you can see primary care of the qualifying child. A caregiver may be given access to the program if they are related to the US-based qualifying parent. So basically, the person who stayed there to take care of your child can be also eligible for this program, okay? So this is really good, right? You can go and look at the eligibility for family members. So they're going to extend it to apply to other family members as well, okay? So, and then you can go on and look at some other things. So let's move on to the, this is a great news really for those parents who are here and their children are still there. It's a really great program so they can reunite as soon as possible. Yeah, this is another policy. USCIS updates policy guidance on self-selecting a gender marker on forms and documents. You know, with USCIS, we just have female or male. We don't have those other, if you identify yourself differently, then there's not, usually there was no option. So now they're saying that you can, in fact, identify yourself the way you want to be identified. So basically, that's basically what they're saying here. I wanted to see if there is another news here. Okay, so this is a good one too. Employers may file H2B petition for fiscal year 2023 late second half returning workers. USCIS has started to accept applications. Okay, if you want to understand what is H2B, you can go on my Instagram, and I've talked about the difference between H2B and H2A. You can learn a lot about it. What else? USCIS updates policy guidance on safe mailing address and case handling procedure for certain protected person. So this is huge, okay? Because with VAWA, sometimes the abuser will call, sometimes, not all the time, they will call or they will give a tip, okay, to USCIS so that they can undermine the other person application. But what USCIS is telling us is like they are not going to consider it as a primary type of evidence. They're not going to give a lot of weight to it. Okay, so pretty much that's what they're telling us in that new policy in summary. So because you're protected, okay, so you see here says that USCIS updated guidance to provide policy guidance, okay, to provide guidance on mailing address procedure for persons eligible for and recipient of victim-based immigration relief, especially of our petitioners, self-petitioners, as well as those who are seeking or currently hold T or U immigrant status, okay? This guidance also applies to abused spouses of certain non-immigrant applying for employment authorization under Section 106 of the Immigration and Nationality Act. So if you go, USCIS must ensure that information related to the protected person is disclosed only to authorized parties. So you can't just call, if you're the abuser, you can just call and try to undermine the other person's petition, because USCIS will not disclose information. And this really just happened to one of my clients, because she actually applied for VAWA with me. However, her green card application was already pending, okay? So then she tried to call USCIS to get information on her pending green card because her VAWA was approved. And USCIS said that they cannot disclose this information over the phone because they really don't know who they're talking to, I guess based on this policy, even if she was the one inquiring about the status of her green card application. So it becomes like basically because she's a protected person based on the fact that she won her VAWA petition, has been granted, approved, so she's a protected person. And they can just disclose the information over the phone. So basically that's what is going on. And you can click here and read more about the policy. You go to the policy at the manual, and then you can read a little bit more. Okay, so let's stop sharing and start answering questions. Okay, let's see. Thanks for answering all the questions in the YouTube comment that day. You were very, very helpful. I am upstate New York. Yay, Chandra 011. You're welcome. I'm impressed. You're nice and great. Thank you very much. Bless. How have you been? Long time. Hello, my sister. Please, is there any hope for people who came in legally but overstayed for 20 years due to illness? Well, we don't have anything going on as of like for now. There's really nothing going on as far as the amnesty. Yeah, unfortunately, that's the case. Really, I haven't heard anything, to be honest. That's why I don't really talk about it, because really there's nothing going on. Let's see 2024 when everybody starts running for the election. That's when people bring proposal. That's about it. So let's take questions. Anybody else has a question? Let's answer some questions. This is the time, right? When you answer you ask your questions and we try to answer those questions. This is the time. Okay. If there's no more question, I don't really, yeah, I don't have any other news. Thank you. You're welcome, Bless. Long time. I haven't seen you on our, we don't do live session a lot, but I haven't seen you since our last one. I mean, you missed at least 3 live sessions. Anyway, so anybody else has a question? If there's no question, then there's nothing else to talk about. So please share this video for this information might help those people from Central America. Um, Esther Monire, are you among those people who are you talking about the CAM program, CAM, CAM, or are you just talking about in general? Okay. Are you talking in general, or are you specifically talking about this Central American program? If you're talking in general, well, father become a stepchild father when the wife get married to that person when the children are under the age of 18, right? So then when the children are under the age of 18, that's and then you get married to that person. Oh, in general. Okay. So let me answer you this question, okay, Esther. So in order for a stepchild to file for their father, right? First of all, we have to establish this step father and step child relationship. Basically, means that the marriage must have been the marriage took place when the children were under the age of 18. That's when the marriage took place. And now that the children are older, 21, and they're U.S. citizen, yes, they can file for their stepfather. But the relationship has to be established first. When did the father got married to you? The children were under the age of 18. So it has to be that you got married to that father I mean, that stepfather when the children were under the age of 18. So that's what establishes the relationship of stepchild and step father for the purpose of immigration, of course. Okay, and if that one is established, then the children now are U.S. citizen. Yes, they can file. Yes, then now if they're 21 and U.S. citizen, yes, they can file for their stepfather. Okay, let me answer this one. Imad Hakim. Hi, if someone has been here in December and apply for extended visa in December, can he apply for adjustment status under 245I? No, that's not how adjustment of, sorry, 245I works. 245I works if you have an old petition. It has to be a family-based, employment-based, or labor certification petition. Old, right? That was filed, that the cutoff is April 30, 2001. And now you find yourself overstay and you are eligible to adjust status, maybe you get married or under employment or something along those lines. So then you're gonna go back and use that old petition that you had in 2001, use it as 245. It has to be family-based, employment-based, or labor certification, not extension of visa. No. Imad Hakim, the answer is no. Oh, you're from Kenya. Esther, yeah. So, yes, again, the answer is yes. When the marriage took place, the children were under the age of 18. And then now that they are 21 and the US citizen, then the answer is yes, they can file for the stepfather. Okay. Nelly, good day. Please, do you know anything about asylum file? Up to now, no interview. Nelly, there's no interview going on for any asylum application. As a matter of fact, I'm filing a lawsuit next month for somebody who applied in 2015 because nobody's calling anybody. If you're lucky, you try expedite request based on humanitarian reason. If you're lucky, you get approved, then they can call you for the interview. I had one client who filed around the same time, 2016. And then we file expedited request based on serious illness. So the client has to go through surgery and implant. And then the doctor had to write letters and stuff like that. So we had to show USCIS, and USCIS agreed to expedite the case. But guess what? They waited for 3 months before calling them after the approval of the expedited request. Uh, they waited 3 months, then they called them for the interview. They just went for the interview last week. They went to the interview, and now they're waiting for the response. So you were deported. Would you have to wait for 10 years for your children to file for you? Were you deported in absentia, like you didn't show up in court? If you didn't show up in court the day you got the order of deportation, then the answer is yes, you should wait for 10 years. But if you showed up, but they actually order you to remove, are you physically in the US? If you're physically in the US, what you're gonna have to do is after your I-130 petition get approved, then you can try to reopen your case with ICE and try to join ICE. We talked about motion to reopen. You can watch that video. It's really going to explain to you how you're going to proceed if you're physically present in the US. Reopen the case, then ask them to adjust status for you. Yeah, you was in court. You don't have to wait. Oh, now that you are in Kenya, oh, this is a post departure. So, yeah, first of all, because you have a bar, and you were deported, so you have to try to reopen the case, because technically you have an order of removal and you're physically deported, and they call it a post departure bar. Yeah, 10 years, yes, you have a 10 years bar, that's yes. But in other words, you can just try to reopen the case and ask if ICE can allow you to apply for adjustment of status. But it's so complicated when somebody's actually outside of the country. So it's not that simple. In other words, you can wait the 10 years, still you're going to face the challenge. You can start now, still there is a challenge to face. Is there any way, other way an overstay can file for a change of status, like marriage? If there, Bless, are you asking if there's an other way? I don't think so. Marriage is like the best way. Married to a U.S. citizen, if you go with employment, you have to have an exception, the 245I. If you don't have a 245I, then you're stuck. But with marriage to a U.S. citizen, then yes, it's possible. Under employment, or if you have U.S. children who are 21 years and older, then they can apply for you too as well. U.S. spouse, U.S. children, 21 years and older, they can apply for you, Bless. But when it comes to employment base, you have to meet the 245I. exception. I guess we answered pretty much all questions. Yes, Esther Monire, it's going to be challenging for you because of the post departure bar. Still, whether you wait 10 years or not, you're still gonna face the same challenge. That's what it is. But it doesn't mean you cannot try. So you can always try and see what's gonna happen. So you can watch my video on motion to reopen, and you can learn a lot and see what's gonna happen. Okay, so any more questions? You're welcome, Bless. Any more questions? Any more questions? If there's no more questions, then we can. Huri, do you have a question? What is your question? We're gonna try to wrap up. So, what is your question? You're welcome, Esther. Is there anything that can be done for kids under the age and out of status? I don't think so. Yeah, to be honest with you, Forest Family TV, I don't see anything. No, I don't see anything. I don't see anything on top of my mind. I really don't see that. I don't know if your children were under DACA, and we know that DACA has been like suspended for new applicants. Old applicants are still renewing, and we're still waiting for the final decision. I believe in June to know the future of DACA. So maybe it's gonna lead some people to get something out of it. We don't know. So let's just wait and see. But out of just like that, no, I don't see anything. I don't see anything at all. Besides DACA, DACA is the only thing that keep other people. Oh, your advance parole has not adjudicated yet, and TPS period expired. Well, when are they gonna up? What is your TPS from what country? So basically, what's gonna happen is when they renew the TPS for the country that you are from, when you apply for the new TPS and you get the receipt, you can take that receipt and send it back to where the your advanced parole TPS application is pending. So that's exactly what you're going to do. Once you renew your TPS, when the registration time happens and you receive a receipt, you take it, you send it to the where the advanced parole TPS application is pending. That's it. And then keep waiting. And to be honest, with those TPS and work permits, people have been waiting forever. And I have clients where we try expedited request, didn't even work. So now they're just waiting until the time to submit an online inquiry. It is so frustrating with those TPS. So, Uri, did you get it? Okay. Well, if the new Uri, why would you apply for a new one? If the one that you apply is still pending, what you're gonna have to do is once you apply for the new TPS, you have a receipt, you send it back there. So that they will know that you still want to travel. It's basically it's called amending your application. So you pretty much just amending a pending application. Because if you start a new I-31 today, then you starting over with the waiting time period. You don't know. I wouldn't. If I were you, I'm not gonna do it. I'm just gonna take the receipt and then send it there and with some note and telling them that I've renewed my TPS spending, and my advance parole travel documents, depending with you guys. This is the receipt. So, okay. So I guess we pretty much cover everything. So if you need a consultation with me, again, consultation link is in the description box. Okay. And you can also share my video, help people subscribe and follow me on Instagram as well and TikTok as well. And we have a Facebook page too, Facebook group. Yeah, we're trying to grow the community. Yeah, Yuri, I already told you, when you apply for TPS, once you get a receipt, you take it and you send it to where your TPS travel document is pending. Yes, because your travel document is still pending. They haven't adjudicated yet. So it's still pending. They haven't come with a decision yet. So basically, by sending them a receipt, with a note, of course, you're trying to tell them that I just reapply for a new TPS, so my TPS is still current. Can you adjudicate my travel document? So I wouldn't start over because you're gonna be waiting. Adjustment of status. Adjustment of status is a different thing. Adjustment of status is like if you get married, and then somebody wants to file for you. That's a different thing. Or you get employment, some employer wants to file for you so you can get a green card. That's a different subject. It has nothing to do with advanced parole and adjusting status. No. Adjusting status is when you have I-130 approved or I-140 approved. Now you start thinking, can I adjust status? Okay. Because of your help with current settlement. Yeah, current settlement, you have to have an approved petition. Huri, do you have an approved petition? That's my question. Do you have I-130 approved? Yes or no? Do you have I-130 approved? If you have I-130 approved, and then you came here without inspection, that's when you need that travel document so you can go out and make the second entry. So you can say that I was admitted the second time. Now, can you reopen my case and adjust status? Yeah. Yes, apply for your I-130, wait for it to be approved. Then you can talk about the current settlement. If you came without inspection, then you can go out to make your second inspection entry. But if you came with inspection, you can just go and do try to reopen the case with ICE. But people are traveling just to make it much easier based on the current settlement. So I guess I'm done. Yuri, you need a consultation. Don't be asking a random question. If you really have a real case, you need a consultation, Yuri, okay? You need a consultation, click the link in the description box. Until next time, bye-bye.